Today's the date and time set for a review hearing, permanency planning hearing, and a trial on the petition for termination of the parental rights of Ms. Samantha Stout. And the names of our participants.
Lee Heights, lawyer guardian ad litem.
Ms. Tasha Thomas, counsel for the department.
Leslie Conrad, foster care worker, Fostering Solutions.
Mariana Ariel Berger here on behalf of Mother Samantha Stout.
Ms. Stout?
Samantha Stout.
Thank you. I understand you had a chance to confer with your client ahead of time, Ms. Berger?
I did, Your Honor.
All right, for our purposes today, given that there's a request to have the court evaluate termination based on whether or not there's been services or progress made on services, it would be my usual methodology to combine the review with the termination proofs. Any objections or comments on that?
No, Your Honor, I believe that's appropriate.
No objection.
No objection.
Okay. Ms. Heights, whenever you're ready.
Thank you. I was able to visit with this child in person. This family, there's 7 children and 6 different moms. And I've met them all throughout representation in this case. And this is the youngest boy of Mr. Young, and he is placed with the oldest children's mom. So the very first person who made a family with Mr. Young had 2 boys. And then from there on, each of Credence's half siblings have a different mom. So he has known them over time, many of them, but right now he's placed with his oldest 2 half brothers. And these 2 young men are in high school, and they golf, and they are in all kinds of sports, and they play video games, and they're so when I visit Credence, those 2 folks are around many times. Sometimes Credence has friends over, and so he has friends in the neighborhood, and they play at each other's house. And a very normal childhood sounds coming from their play. And Credence is very proud that he gets a perfect attendance award nearly every quarter or semester, whichever they call it in elementary school. He wants to stay in this placement. When I visited last, he had a new scooter. And I said, well, a new scooter, you know, it's not Easter, it's not Christmas, it's not his birthday. What is this new scooter? And she said, oh, he wanted it. And I ordered on Amazon, and it came, and he gets to have it. So very attentive to Credence's needs. He's happy, he's lighthearted in this placement. He has a little bit of a speech delay, so he's a little bit hard to understand, but to watch him say something to me and then look to his caregiver to interpret it for me so that he can communicate is interesting to watch. He looks to his caregiver as a support. He wanted to go outside and play on the scooter instead of talking to me. And when his caregiver said, no, you have to wait a minute, that was final. And he behaved for her very well. Well, he rode the scooter inside then, but anyway, a very child-centered home, including the big brothers who take on, half big brothers, who take on a real paternal role, although they're goofy with them too. And, you know, those video games, the little guy, Credence, really loves to be included in any of that kind of stuff. So his relationship with his mother has been that this caregiver, the mother of his oldest 2 half siblings, she allows, what she says is she allows the Credence's mother to call when she wants to, when she can. There was a in-person visit set up, but basically mother takes care of herself, and this caregiver takes care of the child and makes the child available for visits when possible. During this case, though, you'll remember that mother has even borrowed money from this case caregiver, showing to me that there's a good relationship, and this caregiver cares about the entire family, but also that mom is not prepared to meet Credence's needs. Father then also video chats. He has moved placements in his incarceration, so Credence hasn't had that access now for just a little bit, but he wants to stay in this placement. This is stable for him. When we found him in the beginning of the case, he had lived with mom, then he had lived with dad. Then we placed him back with mom, and that didn't work out. So all of his needs are met in this placement. His caregiver works, I believe, full-time and still manages all of his fundraisers for school and all the details he has. She does have funding to take care of him, and they live in a house. I don't know if they own it or they rent, but the entire house is theirs. He has outside and sidewalks. So I would ask you to consider that the relationship, the bond between him and his mother has diminished to the point where it would take an unreasonable amount of time to build that bond back up, considering mom isn't accepting services. So this child needs permanence. He needs to know that his family isn't going to change and that his stability, he has the ability to rely on this family and to really bond with them and know that he isn't going to be moved again. Let me double check. So I would ask you to consider that termination today. When you see the proofs, you'll see that the statutory basis will be met and also that the best interest will be met. Thank you.
Ms. Thomas.
Thank you, Honor. Ms. Conrad, can you please be sworn in to provide a report? Good morning, Ms. Conrad. Would you prefer Ms. Conrad or Leslie?
Leslie's fine.
Okay, thank you. Okay, Leslie, so you are the foster care worker that's been on this case since 2022?
Yes, November 2022.
And you provided a court report for today's hearing?
Yes.
And originally we were supposed to have this hearing, I believe, on March 22nd. So there's been a little bit of a time gap between the time you provided this court report and drafted it. Are there any updates or modifications that need to be made to it?
There has been no verifications of any engagement in services or employment or housing since that date. And there has been 1 face-to-face visit between the child and mom since that date.
So your report, I believe you indicate there were 2 visits since last review period, 1 in person, a call, and then this one.
Correct.
And generally speaking, since the last review period, do you believe that there's been some, let me strike that. How would you describe mom's level of compliance with and benefit from her case service plan during this review period?
The same as it's been throughout the duration of the case, which is no verification of engagement in any services, no verification of stable housing, no verification of employment, and sporadic and inconsistent contact with and visitation with the child.
Do you believe that there's been any change of circumstances that would warrant review or reconsideration of the goal for this child at this time?
No.
And what would be the risk of harm to the child if the court were to return the child to mother today?
So the barriers that existed at the time of the court's removal of the child in November of 2022 continue to exist. There is housing instability, no financial resources, no ability to meet basic needs, and then no psychological evaluation, no individual counseling, no parenting education has taken place, no budgeting education or income management has taken place. So all of the services that were required at the outset of the case none of them have been engaged in, completed, and no benefit has been shown.
You had the opportunity to observe Ms. Stout's interactions with the child?
I have rarely, but I did in March of 2024. There was a face-to-face that I supervised. Yes. And
How
then
would you-
previous to that, just twice previous to that since November of 2022.
3 times total. And how would you describe what you saw in those interactions?
So there are no concerns regarding abusive behaviors from Ms. Stout or neglectful behaviors from Ms. Stout when she is directly with the child during visitations. There are observable concerns regarding a bond between the child and her. In March of 2024, I drove mother to the child's school to pick him up after school and then take him to our office for a visit. And he came into the office and ran into the office and ran to me and hugged me and did not do the same with mom. He talks with her easily. He has zero fear involved with seeing mom, but when they converse at this last visit in March, the conversation that mom had with him in the office was primarily about her friend that she's been living with and what she's been doing. And there wasn't much back and forth as far as how he was doing and what his life was about. She was talking to him about his schooling, and he was telling her about his perfect attendance award, and she didn't know who the principal was that he got to have lunch with at his elementary school. She had to ask him if it was a man or a woman and what the name was. And that was a school he attended prior to foster care. So there's just some pretty significant gaps in the parent-child bond. There is no fear and there is no abuse observed.
To go to the petition for termination, so that this might include time periods that are recapped outside of this review period. To date, have you been able to observe mom's current housing?
I have not observed the inside of the housing, no, just the outside. I picked her up and dropped her off at the housing. She reports is where she's staying. The last time I dropped her off in March of 2024. At the housing, she states she has been given access to. As I was leaving, I was in the driveway waiting to pull out onto the road and watched, and she entered the home through a window, like she opened a window and crawled in. So I don't know if that means that she does have access to the home or she doesn't. I'm not sure.
And you have not been provided like a lease or any rental agreement or anything like that?
No.
And as relates to the psychological evaluation in your report earlier, you indicated that she's still not completed one.
Correct.
And was that ever scheduled for her?
Yes, there were 2 scheduled by me with Dr. Richard Haugen, one in July of 2023, and which she canceled like the day of. So she did cancel with advance notice, although it was minimal. So Dr. Haugen rescheduled for August of 2023, and she did not appear for that one. And after 2 failures to appear, he does not reschedule a 3rd.
And you say that she has not engaged in any mental health services. Were any referrals made for that?
So yes, in September of 2023, yes, referrals have been made throughout the case. Back after initial disposition took place in February of 2023. A referral was made and she was provided information in March 2023 and again in May 2023 for an approved service with Brene Moore for virtual counseling because she was living between Toledo sometimes and Adrian sometimes. That has never been engaged in. And then in September of 2023, Ms. Stout went to an inpatient treatment center for substance abuse, and she was exited from the program after 4 days, but she was given a referral to follow up with local CMH. She did attend a case management follow-up meeting, but did not attend her follow-up psychiatric appointment at CMH. They closed her case eventually, and she did attempt, she reports more recently, to re-engage in CMH services and reports that they told her she does not qualify any longer. So she provided me her Medicaid information. I did some searches for local providers that would accept her Medicaid and referred her to an agency. Just again, now in March, she was given the name of an agency that will accept her insurance, but she had had options for Renee Moore since the beginning of the case. And her information was given to her multiple times. CMH was an option. She did not follow through. They closed her case. We have just given her information again for Mindful Hearts, another agency that accepts her insurance. I do not have any verification that she has contacted them or started services.
Is there any ongoing concern about substance use or abuse?
Ms. Stout states no, and has never engaged in a drug screen or alcohol screen. Those have not been required of her through her case service plan. But she did, again, she voluntarily entered a substance abuse inpatient treatment center for detox. She reported to me for detox in September of 2023, indicating that she did in fact have a substance abuse issue. She was exited by the program for rules violations 4 days after admittance and has not engaged in any follow-up substance abuse services since then.
As it relates to the child's best interest factors, how old is this child?
He is 6.
And would you say that he has a particular need for permanency and stability and finality?
Absolutely, yes.
Ms. Heiss, in her report, has sort of outlined the instability that this youth has experienced early on in his life, with living with dad, brief moment with mom, and then removed, to this caregiver's home. Have you been able to recognize any changes in his behaviors from the time he was placed in foster care to today?
He has never demonstrated any significant emotional or behavioral concerns. So he has not required tremendous stabilization in either emotional stability or behavioral stability. However, what I have been able to observe is the consistent deepening and strengthening of the bond with his current caregiver over the last 16, 17 months. He is very well adjusted. He is emotionally stable. He displays a range of emotions and displays accurate and age-appropriate emotions for the situation. He is very bonded to his brothers with whom he lives. And over time, he has just developed this ease about him that is very focused on having a sense of humor, lightheartedness. He loves to laugh, and he and his caregiver do that together. They have inside jokes that I'm not familiar with when I'm there, but that they laugh about with each other. They tease each other in a very loving way. They're very physically affectionate with each other. Every time I'm at their home, he says something to the effect of, I love Mandy, or I care about Mandy, or I care about you. Or if I bring candy or treats, he'll instantly ask if she wants to share them, or he'll ask if I'll bring her favorite next time. She likes peanut butter cups. And so he is very obviously bonded to his caregiver in a parental role that I have seen deepen over the course of the case.
And during the period of case, has this child been able to provide the kiddo with any material needs or any financial support?
Not consistently. I do know that there have been, I can think of a couple of instances where she has had visitations at the caregiver's home where she has brought groceries. I know on one instance, she brought food and cooked a meal for him at the caregiver's home. And she has provided gifts to him on a few occasions. Yes, but no consistent clothing support or shoe support or school supply support or anything like that.
And at the child's current home with a caregiver, does he have like his own bedroom?
He shares a bedroom with his oldest half brother. He does have a designated space in the basement that has been turned into his playroom, where he has his gaming system, his arts and crafts supplies, a table and chairs, a child-sized sofa, It's outfitted for him because his teenage brothers do have space where they don't always allow him into because they are teenagers. He's 6. And so he does have his own dedicated space in the basement, which I view, and is filled with things for him. He loves to do arts and crafts and build things with paper and glue and tape and scissors, and he has all of those types of things.
As far as policy goes, is this considered a relative placement?
Yes.
Generally, relative placements weigh against terminating parental rights. Can you explain why it would still be in the child's best interest to move towards adoption despite this being considered a relative placement?
Yes, so the child's father has voluntarily released his parental rights to the child, so he no longer has a legal father. He is young. He is 6 years old. He's observed that he enjoys the family feeling within his current placement. It is not it does not feel like when you're there as a visitor, as Ms. Heiss stated, nor to credence or to CY when you observe him, it does not feel like a temporary stop. This is his home. These are his people. These are his brothers. And this is his caregiver. He has been observed to refer to his caregiver as mom when talking to his friends and neighbors and peers. He does not call her mom. He calls her, he has a very familiar nickname that he uses for her, but he does not call her mother or mom when he talks to her. But when he talks about her to his schoolmates, he's been observed to say, that's my mom, or my mom dropped me off or is picking me up. This is not a temporary stop for him. He feels very at home in this placement, and the home kind of revolves around him, to be honest. They very much like to make sure that he is happy and his needs are met. He is only 6. He would thrive in a state of permanence that he knows will not be undone at any given moment and cause him instability or anxiety. The caregiver is very interested in providing permanence through adoption so that she can be his legal parent and he can have a legal parent who he could be an heir to. He will have full legal brothers residing with him. Everyone in the family is on board with this being an adoption, including his father who released his parental rights. He's ready for permanency.
This caregiver has, from your reports and testimony that we've had throughout this case, has been really kind in allowing mom to sort of maybe dictate when she has contact and all of that. And with that, do you believe that that mom has taken advantage of that openness?
I mean, mom has utilized that and does speak to the caregiver through social media and through phone regularly. Has she taken advantage of it to the extent that it's been available? No, because she's been able to, the caregiver has been told from the outset that at minimum, the child should be having 2 times per week visitation with mom. And mom knows that, and the caregiver agreed to that. And that has, and it's a less than 25% success rate in a 2 times per week visitations draft case. So mother does access caregiver easily to request to talk to the child or to request to set up visits, but it just doesn't happen very often on mother's part. This was also alluded to earlier, but mother does have a tendency, or has in the past, reached out to the caregiver, not only to speak to the child and to see the child, but to also get emotional support from the caregiver and to ask for financial help from the caregiver. She has asked for money on more than one occasion from the caregiver.
Does the caregiver have the financial ability to support all of these individuals without a subsidy or income from an outside source?
And no, the caregiver depends on the foster care payments that she receives for the child to meet his needs.
Thank you. I have no further questions of Ms. Conrad. I move to admit the court report.
Okay, let's talk about that for a second. Unfortunately, I just reviewed it all to make sure I had it right. We've had I think 4 different adjournments. So I have 4 court reports. Thank you, Ms. Conrad, very thorough. The first is from services that went from October to December 6th. I have another one that went from after the last court date, the 12/13 through the anticipated date of January 9th. I have another one that looks to replace both of these with a services date from October through the end of January. And then I have, of course, today's, which goes from January to March. So I guess I'm looking for clarification on which one, how many, all of them you'd like me to receive.
Your Honor, those have been circulated and served appropriately. I don't know that I've taken any testimony on the earlier ones given the adjournments, and I believe that some of them were provided because of dad's dates. So I don't know that we ever have had testimony on them. But as it relates to these, if I could have a brief recess to sort of review what I have and compare them, that might be helpful in determining what we need to get into the record.
Any objection?
None.
No.
All right. We're back on the record. Ms. Conrad remains on the stand. You remain under oath. Okay. Ms. Thomas.
Yes, thank you, Judge. Thank you for bringing the court report issue to our attention. There were 2 reports that were offered for hearings that were scheduled. One hearing was scheduled for December 13th, 2023, one for January 9th, 2024. Both of those reports, one is regarding the whole case and is replaced by the court report that was submitted for the January 31st hearing. And then the other report is solely for dad. And so both of those are unnecessary and can be disregarded. So we would just ask the court to consider the court report that was presented for the January 31st hearing. And I can take some testimony on that if need be, or if the parties are willing to stipulate to its submission. Ask that.
Ms. Berger, what are your thoughts?
I have no objection to stipulating to that report. Are we also using the report that was submitted for today?
Yes.
Okay, perfect.
Right, and I received and reviewed those along in the case. We all came prepared when those adjournments came, most of those, and we've been here separate times for Mr. Young. So all of those reports, I have no objection to the court accepting as evidence.
All right, thank you. Well, I will follow the recommendations made by Ms. Thomas. I think that clarifies the proofs by just accepting the one prepared in anticipation of the January 31st date and the one prepared in anticipation of today. All right, so then cross-examination, Ms. Berger.
Thank you, Your Honor. Ms. Conrad, have you been able to meet with Mother recently?
Yes, we had a face-to-face meeting in March of 2024 and in February 2024.
Okay. And prior to that, was she meeting with you regularly?
No.
Since those meetings, has she engaged in any services?
Ms. Stout reports that she has. I have not received any verification from her or from the service providers she reports engaging with.
Okay. And did you reach out to any of the providers since then?
I have reached out to a parent education program she reports that she's attending. They did not respond to me, but Ms. Stout also said to me last week that she had not yet turned in the release. She had just gotten the release of information from them, she reported to me, and hadn't turned it in yet, allowing them the ability to get information about her attendance.
Okay. And you stated that you observed the outside of the house where she's been residing, is that correct?
Yes.
And do you know how long she's been there?
As far as her reporting that is her actual residence at this time, that was told to me in March of 2024.
Okay.
I have picked her up. She has reported staying out there from, at various points in time previous to that, but she did state to me in March that she has been told she can stay there by the home's owner. I did tell her that I needed some sort of information from the home's owner in writing stating that she is allowed to live there, and potentially an assessment of the home, and those have not happened. Neither of those have happened to date.
How would she go about getting an assessment?
She would request, if it was a home that she is asserting she would want to have her child reside in with her, then she would ask me for that via text or phone call.
And has she indicated that she has begun working anywhere?
She states that she has begun working. I have not received any verification of employment.
Okay. Do you know where that is?
She states that it's at McDonald's in Adrian.
Do you know if it's part-time or full-time or any other information?
I don't. From what she has reported to me, she just started last week.
Okay. And have you met or do you know the individual that she is residing with?
No, what she has told me is that she was residing there with a friend. And then she did state that it was a romantic relationship as well. That individual has been arrested and is jailed currently, but she states that it is his father's home. He also lives there, and that his father has stated, she says, that she can continue to reside there while her friend is incarcerated.
Okay.
That's the extent of the conversation or the verification I've received.
Okay. And as far as communication going forward, if there were to be a termination today, do you believe that the current caregiver would still allow or encourage communication between the minor child and his mom?
She has stated that she will maintain a connection for the child and his mother because she cares for the child and wants the child to have a connection if it's important to him.
Okay. Okay. No further questions. Thank you.
Ms. Heiss.
I have no questions today, thank you.
All right, any redirect?
No, Your Honor, thank you.
Thank you for your testimony. You may return your seat.
Thank you.
Anyone else would like us to hear from?
No, Your Honor, I'll allow Ms. Berger to call her client.
Ms. Berger?
Yes. Samantha, you ready to testify?
Deputy Ames?
You'll have to unmute.
Yes, please.
Can you hear me okay, Samantha?
Yeah,
Okay. Did you hear what the caseworker testified to?
yes.
And do you have anything to add on top of that?
I haven't got her no verifications because I did just start working last week at McDonald's. I'm working about 25 hours right now, trying to go to full time to get more hours, but I'm just training these first 2 weeks. In the beginning of this case, when they gave me the service plan, I asked her to help me start doing them right away. I was working at that time and had a car and everything. And she told me we had plenty of time to do it. And when I wanted to start it right away, she didn't want to start it right away. Now I'm trying to, I know I haven't done nothing during the case that much, but because I was really hurt about a lot of stuff, but I'm trying to do better now. And I just want to see if I can get some more time to start engaging in more. I'm in the parenting class. It's every Tuesday, 5:30 to 7. I did do not an assessment. I did paperwork for Mindful Hearts Online. It was all my information that you would fill out on paper, and they haven't reached back to me yet. So I'm trying to engage as many as I can.
What's
It's,
mindful?
Counseling.
And is that online or in person?
It did not say. I think they do both though, by what I've looked up.
Okay. And your employment, is that how it always starts out? Does it start out part-time during training and then you can graduate to full-time, or how does that work?
I'm not exactly sure. Probably goes, yeah. The first 2 weeks is training.
Okay. And how much are you making?
$14 an hour.
And talk to us a little bit about your housing situation.
I do stay with a friend. He is incarcerated, but it's his house. His dad has just lived here. He works full time, his dad does, and he's allowing me to stay here, both of them, so that I can get my mind stable and get focused. Because without the stability, this is the most stable I've been this whole time throughout this whole case, and it's the only thing making my mind get focused.
And how long have you been living there?
Probably about a month and a half, at least to a month and a half to 2 months. But I've been here plenty of times before that, like for a few days at a time or whatever.
Okay. And talk to us a little bit more about the parenting classes. Where are those at?
They're at Comstock. They are called Raising Highly Capable Kids. The first one I did really enjoy a lot. I learned little things and I took notes, and I've been learning a little bit and I've been engaging with them. There's about 4 or 5 of us that go every week. So it's not a big group, but we're all okay with each other and speaking and interacting. I do really enjoy it.
And this case opened in November of 2022, is that correct?
Yeah.
Why has it taken you so long to engage in some services?
Because I was not getting all the referrals that she keeps saying that I was getting. I wasn't getting no support or help from any of the people working in this case. I feel like that I should have gotten more support and help. And I don't know. I wanted to start stuff right away, and they told me, no, you're working, you're driving back and forth to Toledo. So, and now we're at the end where they want to terminate my rights, basically.
Okay. And have you considered engaging in all of the services in your service plan?
I don't know about if I can do, they told me the psychiatric, that doctor was only able to do it. I could only do it through their doctor, I guess, through their psychologist. So I did miss both of them appointments, so they won't reschedule, is what I was told. CMH, the second time I went, they said I wasn't eligible for services. So.
Okay. And have you been in contact with the caseworker monthly since the case has been open?
Yeah, we talk text or on the phone, mainly text.
And have you met with her every month?
I try to.
And how much more time do you think you would need to get your home and yourself ready to be able to parent your son again?
3 months, maybe.
And
My mind is way more focused now.
And do you have a plan on how you could achieve that?
Well, when I first get paid, I plan on getting a vehicle. So once I get a vehicle, I can be able to have transportation to try to get my own. I mean, I don't know if I did an assessment with her and they approved here, or if I still went and got my own, because my son has 3 other children, or 3 other siblings too, that are my other children. Everyone talks about his other 7 siblings. He has 3 siblings that are my other children also.
Okay. And do you have visits with them?
Yeah.
Okay. Is there anything else that you want to add today?
I just want to ask for more time so I can show you guys that I'm dedicated and focused to get everything back on track.
Okay. I don't have any more questions for you, but some of the other lawyers may, okay?
Okay.
Thank you. Ms. Stout, when you said that you did not receive any of the referrals, do you know why? Like, can you tell us a little bit more about that?
She keeps saying she gave me all these referrals to different places. She's never gave me all them referrals to all them places. Half them places on that court report, I don't even know or heard of them this whole case.
Do you recall being scheduled for psychological evaluations?
I do that, yes.
Okay, and you did not attend those?
No,
And you were, did you provide, or were you provided support in contacting CMH or talked to about utilizing CMH services?
can you repeat that?
Were you supported in utilizing CMH services or told to use CMH services?
She may have referred that one. There's like 3 counseling places on that paper that I've never even heard of throughout this whole case. I don't know where they came from.
And so Brene Moore, did you ever reach out to Brene Moore?
I don't know who that is. I've never heard of that counseling place this whole time. I reviewed the court thing the other day. That's how I know that it's on there.
And did you review all the court reports during this case?
Yes. A lot of it was I was going back and forth from here in Toledo too, and I had Ohio insurance. Now I'm staying in Michigan. I'm not going back to Toledo. So I had to get all my insurance like switched over and everything. So it was hard to even start engaging in services.
What services do you believe are necessary for you to achieve stability so that you can provide permanency for your child?
Maybe some counseling, but I feel like my mental and emotional state is a lot better than it was in the beginning of the case. Really, I just need to be stable, like have all my stuff for me and my kids and just work, and I'm good. I wasn't, in the beginning of this case, I was working. I had a car. I asked them if I could take my son to a family shelter when they first wanted to remove him. They told me no. I would have had housing 17 months ago probably, but they refused me to take him to Toledo family shelter. But they wanted me to go to the shelter in Adrian. I did not want to come back to Adrian.
And you mentioned that you have 3 other children?
Yeah.
Okay. And how old are they?
16, 11, and 9.
How often are you getting parenting time with them?
Every time I'm in town, or my daughter calls me every single day.
So there's no like strict schedule or anything like that?
You know,
Okay.
as long as their grandma's there.
Okay. And prior to the child in this case entering foster care, he lived with his father, correct?
Yeah, temporary while I was in Toledo.
Okay. How often was he seeing his siblings from your side?
They would come down to Toledo, all of them together, like probably at least for a weekend out of the month for sure. It was depending because I couldn't get housing over there. If I would have ever got housing there, they would have just moved to Toledo with me, all of them.
And have you discussed with the relative caregiver about your other children seeing this child?
She knows. My kids have been over there with me before.
Okay. Okay.
My boys have stayed the night over there with them before. She knows my other kids very well.
Okay. In an earlier report, there's an indication, and as Ms. Conrad testified, to substance abuse treatment at some point in time in the fall. Have you had any further treatment for any substance abuse, or are you engaged in any like AA, NA, or anything like that?
No.
Okay. Okay. How would you describe your bond with your child?
I think you guys fail to realize that. Do you guys ever ask him, do you want to go with your mom? That's every time they talk about his caregiver. Yes, he loves his caregiver. He's known her since he was 6 months old. He's always called her baby because he could never say her name. So he's always loved his caregiver. He's a very loving kid to everybody. He loves everybody. And we have a good bond. If they were to ask him, I'm sure he would say that he would want to come back with me, but they probably just keep asking him, do you want to stay here? I don't know what they ask him specifically, but they probably don't ask him, do you want to go back with your mom? Because I know they don't want to throw that in his head probably, but they act like he does not want to come back with me. And I'm sure that he does.
And you indicated that it would take about 3 months to get in a position where you could take care of him. What would that look like for you? Like, what would housing look like? What employment look like? Can you tell us a little more about that?
Well, hopefully I'll have a car, so I'll have transportation. And then I'll have either housing here, if I can do assessment, or I'll talk to Leslie about that. If not, then I will get a different apartment or house. Something that is permanent, whether it's here or another place.
Does the house that you're staying at right now, would it have a bedroom for him or space for him?
Yeah, there's 2 empty bedrooms.
Okay. And is that still sort of in the area where he could continue being in his same school?
I'm not sure I don't know what district, or I don't know if this is the Tecumseh, but I will take him to his school.
Oh, okay, okay.
Because I wouldn't want to take him from his friends and everybody there.
Okay. All right. I have no further questions. Thank you.
Ms. Hess,
I have no questions, thank you.
any other witnesses or reps?
Nothing, Your Honor, thank you.
All right, Ms. Heiss, anyone you'd like to see here from today?
I don't have any witnesses today, thank you.
Very well, closing comments then.
Thank you, Your Honor. As this court is very aware, for purposes of the, for purposes of review, we do ask the court to, I guess, if the court is not inclined to enter the relief requested from the petition for termination from charge, we would request just a standard 90-day review to allow mom to provide the proofs that she says she has, and so we can, hopefully see some stabilization. And in 3 months, that's supposedly when she would also be capable of caring for the child more full time. But as it relates to the petition for termination, we are requesting the court find by declaring convincing evidence for the record, as this is one continuous proceeding under MCL 712A.19B3, that it has been 6 months or more since the initial dispositional order, and the conditions that led to adjudication continue to exist as relates to mother, which I believe Ms. Conrad specifically reported on during her testimony, such as the homelessness, instability with more some of those basic needs. And the lack of receiving any mental health treatment or participating in services, and that there's a reasonable likelihood that those conditions would be rectified within a reasonable amount of time. This kiddo has been in care for more than the 15 months now, with minimal progress being made towards achieving that permanency and stability that he needs. And with his father voluntarily releasing his parental rights, this child is in the brink of being able to achieve permanency through adoption. This court definitely, or generally, does not consider subsection G of MCL 712A.19B3. But I would ask the court to perhaps consider it in this case. There's no proof that mom cannot work, and she was working at the onset of the case, as she reports, and is now, but this, and giving her credit for bringing groceries sometimes, or cooking, or bringing gifts, she has not maintained the financial support to the child that the child needs and the caregiver of the child needs. There's no reasonable likelihood or expectation that the parent could provide that proper care and custody within a reasonable amount of time, considering the child's age and how long this case has been going. We've heard the testimony about mom also having to reach out to the caregiver for that financial support, which in some ways seems like it would be taking those financial resources out of the child's mouth, so to speak. And then under subsection J, there's reasonable likelihood based on the parent's conduct or capacity, the child would be harmed if returned to the parent's home. And as that stands today, I think that that's also true, given the testimony that we've heard As it relates to best interest factors, the preponderance of evidence from the case as a whole and the file as a whole indicates that it is in this child's best interest to have the parental rights terminated for adoption purposes. This child is young, 6 years old, and has been in care for over a year and really does need that finality. As we've heard the testimony, the child is really coming into his own now that he has had some stability in his life for the last year or so. Although the child does, have this recognition of his parents and his mother, that bond does not look the same as it does with the caregiver. The parenting ability, our case law supports that the parent's parenting ability is also reflected in the parent's compliance with and benefit from their case service plan. So I would ask the court to consider that and as it relates to that factor. This foster home has created a very child-centered environment for the child. It really revolves around the child, as we've heard. The child has age-appropriate materials in the home and is protected from any unsafe individuals. Because we have not been able to observe Ms. Stout's home or those who live in it or would live in it, I think that factor also weighs in favor of termination at this point in time. The parent's visitation history with the child, I think in this case is also unique, given that the parent had the ability to reach out and see the child pretty much at her own discretion with the support of the relative caregiver, and has a 25% participation rate considering the parenting time being offered twice a week. And I know that this court must consider the fact that this is a relative placement. One, this is relative placement through the paternal family, so to speak, as it's a paternal sibling's parent. And also, although this parent could have benefited from this relative placement, that might have afforded some time, additional time, she did not take advantage of that open home that we would typically see, and where that factor would weigh against termination. This relative placement is willing to provide permanency through adoption. There are half siblings in that home. It sounds like even the half siblings from the mother's side are welcome at that home. And this caregiver has really supported the child in all of those ways. So for those reasons, we do ask the court to terminate Ms. Stout's parental rights and to allow this child to be adopted. Thank you.
Thank you, Your Honor. At this time, we are asking for one more reporting period. My client is fairly honest in her lack of engagement up until this point, and cites that she is now more stable with her housing and hopefully with this new employment so that she can work and provide for her family. She has engaged in some parenting classes. It sounds like she did apply for counseling services through Mindful Hearts Online. So hopefully those are services that she can engage in and move forward with. It seems like she does have a fairly reasonable plan and reasonable timeline where she thinks that she could get her home together for her child and to be able to care for him. So we are asking for one more review period to allow her the opportunity to do those things and to hopefully fully engage with the department. Thank you.
Hang on 1 second, Ms. Dice.
Your Honor, I would ask you to consider the credibility of the mother's testimony today. I briefly looked back, and as far back as October of 23, the court report, which it sounds like mother has reviewed the report for today, that court report says that she has failed to contact Brene Moore. So also, the court reports continue to show that the agency had attempted to meet with her for months to assist in moving forward in the case. However, she has been unwilling to schedule and keep any meetings with the worker for most of the duration of the case. And that was in January of 2023. I'm sorry, 24. January of 2024. So her saying that it was the agency who failed to reach out is contrary to what we've heard throughout the case. And it hasn't been a defense until today, so that I would ask you to consider her credibility doesn't match the level of the agency in this case and the level of services they're prepared to offer and towards reunification. And this mom didn't do the services. I would ask you to consider that, like the father, I think these parents' actions show how they feel. And I think that their actions are that they accept, if not approve, that the placement is in the child's best interest. There is no urgency for mom to get her services done because I think she knows the child's doing very well where he is. So I would ask you to consider that it is in the best interest of this child for you to determine that the mother has failed to benefit from services. Statutorily, she is eligible for termination, and it is in the best interest of the child. Thank you.
Thank you. Well, the court finds all interested parties were given notice for purposes of today's review hearing, permanency planning hearing, as well as hearing on the petition to terminate the parental rights of Ms. Samantha Stout. We have a number of adjournments taking us from late 2023 through to today. Some of those were to allow for the department to file an amended petition clarifying exactly what their position was as it relates to Ms. Stout. And at least one of them was in order to make sure that she had a copy and could prepare for today. As a result of those delays, Ms. Stout has already been given an extended period of time past what the court would usually have to look at for purposes of termination. We're at 16 months since removal at this point. And typically after a year, I start looking at permanency within 6 months. At a year, I'm usually asking the department to get their petition filed, their position solidified. And today we find ourselves at 16 months. And I want to say too, that that's a 16 months that I want to put into context at the outside of this case. There was a lot of credibility were given or granted to mother at the time. Some of the issues were, of course, she needed employment and housing and the ability to provide for her child's needs. She was residing with a legal father of the child at the time who had significant concerns against him. He had hurt one of the other children and had some concerns about improper touching. He's now released his parental rights and is currently incarcerated for things that arose out of some criminal allegations that resonated, frankly, with the concerns that the department raised at the time of the removal of this youngest child. Despite many times stressing to Ms. Stout about those concerns, she continued to expose the child to his legal father, finally causing the department to ask me again. They were very persistent. So I came in asking for removal. I denied that. I gave Ms. Stout the benefit of the doubt at that time, allowed her to stay there, only to find that she was granting still unsupervised, unfettered access of the child to the legal father, who was really had some very significant concerns, including allowing him to pick the child up from school. It just as though she was unable to really understand the risk that this person posed to this very young child. He couldn't have been, I don't remember exactly his birthday, he's 6 now, so he was removed back in November of 2022, so he was probably 4. So, so then that child is finally removed. I, against the recommendations of the department at that time, I insisted that this child stay with the mother of 2 of the other children. That turned out to be a great idea, so I'm glad that that worked out. I know that part of the reason that that was something that even Ms. Stout supported and advocated for was because she was able to stay there, at least at times. She had access. This parent of the other 2 children is very supportive of Ms. Stout, continues to be very supportive of her, as we hear in the reports that continued from that point, including allowing access for visitation and contact, and really doing a lot of those things that we hope that a relative will do. In this case, she's also provided a very good home for this child, and the child has thrived. He's meeting all of his developmental milestones. He's expressing a range of emotions as expressed today by our foster care caseworker, and is doing very well in that placement, enjoying spending time with two of his half brothers that are there in a family-like setting that revolves around him. So I have to look today at whether or not termination of parental rights is accurate or appropriate. There's two stages for that. One is whether or not there's clear and convincing evidence under the statute to support statutory grounds for termination. The second is whether or not it's in the child's best interest to terminate parental rights. It's part of what the court's been asked to evaluate from the statute. MCL 7128.19B3 CI asks the court to look at whether or not the parent was a respondent in a proceeding brought under this chapter 182 or more days have elapsed since the issuance of the initial disposition order. And the court, by clear and convincing evidence, finds that the conditions that led to the adjudication continue to exist, and there's no reasonable likelihood that the conditions will be rectified within a reasonable time considering the child's age. As I stated, I will say I slowed these proceedings down significantly at the outset of this case. So by the time this child was removed, we'd already been seeing the department actively working with the family to try to safety plan and to try to move in the least restrictive manner, the most family-like setting for this child. And we finally ended up with mom's initial disposition being February 2nd of 2023. So just a little bit over a year ago. And that was when the case services plan was put into place, addressing many of the issues that we continue to hear about today: stable housing, transportation, access to services to make sure that there was no drug use or untreated mental health issues, employment so that she can provide for the child. And those continue to be struggles today. So there's no question that Ms. Stout was a respondent in this proceeding, that we've had more than 182 days since the initial disposition. It's been over a year. And all of those issues that led to the adjudication do continue to exist. And starting with some of the basics, we heard today from Ms. Stout that she's been there at where she's staying now for about a month and a half, 2 months. She's been there on and off since that point. She's had intermittent success in finding places to stay. This one is also one that seems, frankly, unstable. And I just say that because it is the residence of her significant other who's currently in jail. His father is staying there, but she's not on a lease. She's not providing any kind of support, rent, or anything else that would give her leverage to stay there in the event that her romantic partner was released from jail and decided he wanted her to leave immediately. Employment-wise, that's been intermittently successful as well, with mother reporting at different times that she's had different occupations and temporary employment opportunities. And today we find her successfully employed for approximately a week at McDonald's. But again, we need her to demonstrate that she's able to continue to maintain that employment, continue to maintain a housing to allow her to get to that employment. She currently finds herself without transportation and employed, but not in a way that the court could find reliably meets the goal outlined in her case services plan as it is intended, which is to provide a safe, stable environment for her child in the long run, and to show us that she can be a stable and permanent person for her child. The time frame during which the court has had jurisdiction, she has sought emotional and financial support also from the woman who is providing for her son at this time. It's remarkable, frankly, at the last observations that Ms. Conrad had of her during parenting time, that she was asking questions about education, schooling, the principal, all questions that she should have had answers to since he's at the same school that he was at before he was even removed, which just indicates that unfortunately Ms. Stout is still at a place where she has to prioritize her own needs over her child's needs and is unable to offer to him what he needs, which is to pay attention to what he needs and who's teaching him and who the principal is, and all of those things that he really needs to understand that he's going to be supported moving forward in continuing to meet his goals. I do think there are reasonable efforts that were made towards the goal of reunification in this family. Those are documented, well documented in the court reports and the testimony offered by Ms. Conrad today. And Ms. Stout has to admit that she has had some referrals, at least that she's aware of, for something like a psychological evaluation, for example. We have in the past allowed parents to use other psychological evaluators, but Ms. Stout has not been engaged with anyone who could do that, even intermittent engagement with CMH services. She wasn't able to maintain that, to ask them for a psychologist or psychiatrist to weigh in. So she hasn't allowed herself the opportunity to use other services or the services that were offered to her, and despite a number of months that those are available to her. So I do think that the appropriate goal in this case is adoption. And that supports the court's findings also that there's clear and convincing evidence that the statutory grounds for termination do exist. It's been more than 6 months since some very clear goals were set for Ms. Stout. I think she has given us what we can see as her best efforts, frankly. And I hope that her period of stability that she seems to find herself in now is something that's lasting for her. But I cannot ask this child to continue to wait to see if that's going to be something that's significant. We need at least another 6 months of her showing us that she's gainfully employed, steadily housed, has appropriate housing for her child, that she knows what his needs are, knows who his teachers are, and if you compromise that against where he's at now, he's simply not something that I can allow to move forward. I do think that given the amount of time she's had, that demonstrates that there is no reasonable likelihood that the conditions could be rectified within a reasonable time, considering his young age. He's been removed since he was 4. He's been staying with a person who he's known really since birth, and that's a very stable situation for him. I will not ask him to wait 6 months to a year to see if this particular stage of stability for Ms. Stout is one that she can maintain. He needs to know that he's going to be in a stable, permanent environment moving forward right now. For more than 1/3 of his life, he's been approximately 1/3 of his life, he's been in flux, and that's long enough. As part of the regular findings also, and for today, I do find there's a reasonable likelihood based on the conduct or capacity of Ms. Stout that the child could be harmed if he were returned to her home. Again, she's demonstrated she's got employment at the moment, but we would need to see that stay. We would need to see her be able to transfer him to school, which she cannot do at this time, to meet his needs on a daily basis, which she cannot do, to visit with him, which she's done only 1 out of every 4 times, which is at best once every other week, despite the clear opportunity to do so and where he's placed. That instability and those issues that were raised around mental health and drug usage also continue to resonate as a significant risk in the event that this child were to have to depend on his mother solely for his activities of daily living, his education, his caretaking. So for those reasons, the review is satisfied, and I do find that there is clear and convincing evidence under both aspects of those 2 pieces of the statute that termination of parental rights is appropriate. That's despite the relative placement, which takes me into the best interest factors. We have, of course, the support of the department as well as our caseworker and our guardian ad litem that the termination of Ms. Stout's parental rights is in the child's best interest. The relative placement is one you don't really see as a relative placement very often. I just want to take a minute to really commend our placement for what she's done in stepping up to support Ms. Stout and this child and really creating a home for him where he's able to enjoy time with his brothers and enjoy time with her. It's very unorthodox and very refreshing to see that that's still possible. He's doing excellent in her care. He's very bonded with her, very bonded with his brothers. He clearly needs that. He's thrived since he's been in that home, which we do for purposes of the best interest determination have to look at in comparison to where he would be staying if he were staying with his mother. Her romantic partner is currently in jail. sure that there would be significant concerns about that household and the people that are in it. If the agency were to evaluate that as a place for him to stay, and which is clearly not an issue where he's at now. He has expressed wanting to stay there. It's very clear he's happy there. There's a very high likelihood of him being adopted. He's of course with his two brothers, and he's enjoyed the opportunity to see his mother extra if she so chose. She was unable to do that despite the relative placement. So I do think that even though this is technically a relative placement, there's clear evidence here that despite that, it's in his best interest for the court to terminate the parental rights of Ms. Stout. She will clearly be able to maintain contact with the child if that's a resiliency point for her. This placement is always stood behind him in that point, but it is clearly in his best interest for him to be able to enjoy where he's living now as a permanent placement through adoption. So that will be the goal moving forward. He will remain placed there as we enter into post-termination review hearings. No further efforts towards reunification required by the agency or the department. No further efforts to prevent removal. My decision today is clearly one that can be appealed to the Court of Appeals, and we'll send out a copy of the order terminating Ms. Stout's parental rights, as well as her right to exercise her appeal, including the right to ask for an attorney if she can't pay for one on her own. And the court would be able to provide that for her, as well as a copy of the transcript if she wants to appeal today's decision. That's got to be done within 21 days, Ms. Stout. So please pay attention. We'll make sure we send a copy of everything to you by email, as well as first-class mail, so that you can have access to those forms if you choose to appeal today's decision. In the meantime, the child will remain placed for exam pending our next post-termination review hearing, which will be July 3rd at 9 a.m. in front of our referee.
May I have just a minute, Your Honor, before you close the record? Your Honor, I would ask you to consider that this is a direct placement, and at this point, I think the agency would approve the placement for an agency placement, and I would ask you to make that change.
I believe the orders generally reflect that a placement is within the discretion of the agency, and then I usually just remark in the others section that it's a direct placement, so I can simply leave off that last bit. Or I can leave in a remark that he's placed with her. It's up to you, whatever works.
I would say that Kelly Allen, who helps us with the funding, would need a more, there's another box to check to say that it's direct in the care and custody of DHS, and I'm not sure which paragraph form that is.
I've got that box checked.
Okay, thank you. That's good enough.
Very good. And if there's any issues, we'll be happy to work with her or the department on clarifying. Any other questions before we close the record?
None.
No.
All right. Thank you, everyone. We'll see you in, well, it'll be post-termination of the code, so we won't have any more regular hearings on this other than in the courtroom proper.
Are we ready to proceed, Mr. Malero?
Yes, we are, Your Honor.
All right, we are on the record in file 23-21305-FH and 23-21306-FC, People versus Eric Michael Young. We are here for a final pretrial in the filing 305 and pretrial in filing 306. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Mayor. Doug Hartung, appearing for the people.
Salvatore Malero on behalf of Eric Young.
Okay, and Mr. Malero, where do we stand with Mr. Young's cases today?
Your Honor, I believe we have reached a resolution. I'm going to place that on the record. If I am mistaken in anything, I'm sure Mr. Hartung will provide clarification. So, Your Honor, on the 305 file, Mr. Young will be pleading no contest to count 1. On the 306 file, Mr. Young will be pleading no contest to a CSC second with a supplement, 1 supplement, and he'll be pleading guilty to the supplement or habitual notice. So it's no contest to the facts, but guilty on the supplement. We have a Killebrew agreement of Mr. Young will receive a sentence of 8 years on the minimum. And then we have a request on bond conditions after the plea is entered. I think that.
All right.
Oh, and the count 1 is a 15-year felony. and the CSD second is a 15-year felony.
Okay, Mr. Hartung, is that a complete and accurate statement of the plea agreement?
I believe it is. I just want to make sure on the record that the salt that he will plead guilty to is for both files. So
Okay,
he'll create,
that's fine, Judge. Or, I mean,
he'll
that's,
create a 22.5-year cap on the top end. We've agreed to an 8-year sentence on the minimum. The victim's families have approved this. And these sentences would run concurrent.
yes, that's right. Sorry, correct. Yes.
Okay, so
Yes, that
the
is correct.
second is, I'm sorry, what was that again? It's a second offense?
It would be a second offense, so it would increase it by 7.5 years on each file for this particular plea.
Okay, Mr. Young, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
You are Eric Michael Young?
Yes.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 23-21305-FH? I'm sorry, plead no contest today in that file to third-degree criminal sexual conduct?
Yeah.
Is it also your intention to admit a second habitual offender notice?
Yes.
Do you understand that with respect to that charge, then the maximum possible penalty would be 22.5 years in prison?
Yeah.
With respect to the 23-21306-FC file, is it your intention to plead guilty to count 2 criminal sexual conduct second degree? I'm sorry, I was not able to hear your answer.
Yeah.
And is it also your intention to admit a second habitual offender notice in that file as well?
Yeah.
And do you understand that with that second offense notice that the maximum possible penalty for that charge would again be 22.5 years in prison?
Yeah.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yeah.
Do you wish neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it on the record here this morning? Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Malero?
That is correct, Judge.
Is that also your understanding, Mr. Young? I'm sorry, the microphone there is bad. Was that a yes?
Yeah. Yeah.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Young, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Sorry, I wasn't able to hear what you said.
Yeah.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yeah.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Young, that by entering a plea to these offenses that you will be required to register under the Michigan Sex Offender Registration Act? Sorry, the microphone didn't catch your voice again.
Yes.
How do you wish to plead to the charge in file 23-21305-FH that on or about June 10, 2022 in the city of Adrian, County of Lenawee, that you did commit the offense of criminal sexual conduct third degree?
That would be no contest, Judge.
Okay, so Mr. Young, if you want to plead no contest, you need to say no contest. Sorry, the microphone's there, not good there.
No contest.
Can you try sitting a little closer to the device?
No contest.
Okay, thank you. And in file 23-21306-FC, So I don't have years on this.
This is the one that we amended and filed with the court and gave to Mr. Malaro yesterday.
Oh, I'm sorry.
That's okay. You may not have received it yet. I can put those dates on the record if you'd like me to.
Go ahead, please do.
It is December 1st of 2013.
Okay, so Mr. Young, if you want to plead no contest, you need to say no contest. Sorry, the microphone's there, not good there.
No contest.
Can you try sitting a little closer to the device?
No contest.
Okay, thank you. And in file 23-21306-FC, so I don't have years on this.
This is the one that we amended and filed with the court and gave to Mr. Malaro yesterday.
Oh, I'm sorry.
That's okay. You may not have received it yet. I can put those dates on the record if you'd like me to.
Go ahead, please do.
It is December 1st of 2013 through December 31st of 2015 for counts 1, 2, and 3. And then count 4 was the June 10th of 22 date.
Okay, so Mr. Young, how do you wish to plead to the charge that on or about December 1st, 2013 through December 31st of 2015? And it doesn't have city, township, or village in my information.
That's Adrian City.
In the city of Adrian, county of Lenawee, that you did commit the offense of second-degree criminal sexual conduct. I was not able to hear anything there. Sorry, can you try one more time?
No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to those charges? I need you to sit closer to the device. It's not getting your voice.
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Young to plead no contest?
No, Your Honor.
Judge, I think we should probably add that all remaining charges would be dismissed at sentencing. Other than that, there are no other inducements other than it's indicated on the record.
And I presume you're in agreement with that, Mr. Hart?
That's accurate.
Okay. Mr. Young, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead no contest today?
Yes.
All right, Mr. Malero, would you like to review the factual basis?
Sure.
I can do that if you prefer, Mr. Malaro.
Yeah, I would prefer Mr. Hartung to do it.
Okay.
That's okay with the court. I'm going to summarize the testimony of the two minor victims from the preliminary examination that was held before Judge Morgan on March 16, 2023. In file number, it ends in 305 FH, the minor witness, whose initials are GW, who was 15 years old at the time of the incident, testified that she was by the defendant Eric Michael Young at a residence on Budlong Street in the city of Adrian, Lenawee County, Michigan, and that the assault happened over a period of time in the house that Mr. Young was living at on Budlong Street. And in file number 306, with the dates between 12/1/13 and 12/31 of 2015, the minor victim, who was at age 8 at the time of this particular incident, testified that she was assaulted by Eric Michael Young in her bedroom on Treat Street in the city of Adrian, Lenawee County, Michigan, during that time frame. Both of these young victims testified, and their mothers testified as well, that the defendant had a romantic relationship with each of the mothers and made access to the minor children through that avenue.
All right. Mr. Malero, do you agree that that satisfies the factual basis?
I would agree, Judge.
Right. Has the court complied with MTR 6.302 B, C, and D, Mr. Hartung?
On that part of the plea, yes, Your Honor.
And I apologize. So we need to review the habitual offender. Mr. Young, do you agree that on or about February 18, 1998, you were convicted of felony breaking and entering into a building with intent in the 37th Circuit Court, that's Calhoun County, Michigan?
Yes.
Do you also agree that on or about November 6, 2013, that you were convicted of possession of a controlled substance Cocaine pound.
I'm sorry, do we only need to do one?
Oh, I apologize. Yeah.
We're only doing one, but we're only taking it for one, Mr. Malaro.
Right.
Okay.
Oh, are you gonna do one for each, I take it? Is that what we're doing?
They apply to both files.
Yeah, I think the one conviction can apply to both files, so I think
Yeah,
we're all
okay.
set.
Thank you, Judge.
My eyes were on the notice that I had, so
That's right. You had a tough morning, Judge.
no need for additional, all right, so I'm sorry, has the court complied with MCR 6.302 B, C, and D, Mr. Hartung?
Yes, Your Honor.
Mr. Malero?
Yes, Judge.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Young has had full knowledge of his rights and he's had competent counsel. Other than, as we've discussed on the record here today, of course, not made any other agreements regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to probation department and set sentencing for March 8th at 8:15 a.m.
Judge, two other matters, if I may.
Yes, go ahead.
First, Mr. Young would request to be present in person for sentencing. And the
Okay.
second request is, Mr. Young's asked me to request of the court that he be granted a PR bond pending sentencing so he could spend that time with his family. He has I think a 9-year-old son that he, I think this court might be familiar with, is engaged in a considerable amount of parenting time litigation, and he would like to spend some time with his son prior to the sentence being imposed. That's our request.
Mr. Hartung, people have a position.
We would obviously oppose that request, Your Honor. It's only a very short period of time between now and the time of sentencing, and he's looking at a rather lengthy prison term.
All right, at this point, we do have convictions on two very serious crimes, and those are going to carry with them prison sentences. And at this point, I don't feel, based on that it would be appropriate to release Mr. Young on a PR bond, so I'm going to deny that request.